streaming. I'm going to turn the live streaming on now. And when I turn it off at the end of the day, there'll be 90 seconds lag, I remind you. Councillor, are we all ready? Yes.
The air conditioning on, but I don't know.
If they've got it set up for fresh air, then they can.
Well,
But I don't know.
I did send an email to accommodation, so.
Courtroom is ready.
I just report it. I asked for it to be urgently done.
Yeah.
Accommodation said they were going to send it to you.
You never know.
I
Turned it down, yeah, but I don't think it does anything. It didn't seem like it was actually doing anything. Right. Are you ready?
Court rise.
Yes, Mr. McKendrick.
Thank you, my lord. Before the adjournment, I was dealing with the interrelationship between Gillick competence and the MC, and I have two further points to make on that. And perhaps I may ask my lords, my lady, to turn back to the decision of Mr. Justice Cobb in SA to make one brief point about that. I'm asking the court please to go to page 392 of the core bundle of authorities. Perhaps I might invite my lord, my lady, to read paragraph 19, which places into specific context the decision why Mr. Justice Cobb imported some aspects of the MCA into Gillick competence. Paragraph 19 on 392.
Yeah.
And really, there's 2 points I take from that. First of all, his lordship is concerned with the judicial approach to the determination of capacity competence, and he's concerned with the Adoption and Children Act 2002, and takes the view not only is it a good idea or common sense, but in fact it would be illogical to apply different tests given the nature of the exercise. Now, what we say is that that doesn't apply in respect of medical treatment pre-16 and post-16. And Parliament's been very clear that the MCA applies post-16 and Gillick competence applies to that point. So the specific context of Mr. Justice Cobb's decision, given his judicial function looking at the Adoption and Children Act, is particular to that decision, and that decision must be read in that context. I don't think I'm aware of another decision where a judge sitting at a family jurisdiction has imported some aspects of the MCA to Gillick competence, and that explains why that took place. It doesn't apply in the case of the court's analysis of the decision below. Turning then, I don't ask my lords and my ladies to turn it up. We have NHS Trust in X, and I think all counsel have referred to Sir James Mumby's analysis, which is at paragraph 73 on page 423 of the core bundle. We respectfully adopt the analysis of Sir James Mumby. Perhaps I may ask the court please to turn to page 423 of the core bundle of documents, not the authorities bundle. I apologise, page 294. And this is my client's written submission intervening. And on behalf of the two trusts, I've set out at paragraph 23 at A to G.
Sorry, Mr. McKendrick, I've got a piece of paper that says it's a placeholder for written submissions.
That was the original bundle. I think anticipated they would go in, and then a further bundle was produced with the submissions in. But I don't know where then my lady will find my written submissions.
Well, not to worry, I'll...
Do my lords have the same difficulty? No.
I've got them.
Ms. Morris has an unmarked copy. Perhaps I may.
My lady, I've got an unmarked copy.
Oh, that's kind, thank you. Unfortunately, the perspex means we can't share.
Yeah.
Thank you, Miss Morris.
So paragraph 23 you were showing us, which my lady will have in a moment, but it starts by saying this is wrong because.
My lord,
so
yes.
We need to be reminded what this is.
My lord, the is the partial application of the Mental Capacity Act test in respect of Gillick competence in the context of medical treatment, which leads to the declaration at paragraph 138. And I ask the court to take into account those different factors, because this is a point of some concern for clinicians, that in a range of complex or difficult medical treatments, the courts may decide to draw up lists of relevant information, which clinicians are then expected to follow. We respectfully say that that is an error of approach. It is one which is aligned to the specific circumstances of the assessment of mental capacity, which requires a close analysis between the symptoms of a disorder and the relevant information specific to the decision. There is no reason to depart from the common law test set out in Gillick, sufficient understanding and intelligence to understand fully. If Parliament wished to legislate for some partial or full implementation of the Mental Capacity Act, it would be able to do so. And I make the additional point, without labouring it, at paragraphs 24 and 25 of my written submission on page 296, that of course prior to the implementation of the Mental Capacity Act in 2007, there was a common law test for adults' consent from at least, in the matter of C, a decision of Mr. Justice Thorpe, as he then was, from 1994. Those common law tests did not align. There was a different test from 94, even though Gillick continued to apply. So it is an error of approach to make the declaration as set out in paragraph 138. For those reasons related to the interrelationship, my Lord, my Lady, between the MCA and Gillick competence.
And that's because the language of the MCA was used.
My Lord, yes. And the process of identifying relevant information with the rigour with which the Divisional Court adopted. Now, the point is made by Mr. Hymes in his respondent skeleton, yes, but isn't that what Lord Scarman undertook in Gillick? And we say it's not. There's a very significant qualitative and overall difference between the explanation Lord Scarman gives for why a child may have sufficient maturity and directs that question, that factual inquiry, at the clinicians. So Gillick is not an answer, and it's our reading, without going back to it, that Mr. Justice Silber in R. and Axon does not develop a list of relevant information at either paragraph 90 or paragraph 154. If I can move, my Lords, my Lady, to my second subset within the law, this turns on the question of the autonomy of the patient. And I have to ask my Lord, my Lady, to go back to Lord Scarman, sitting in the mid-1980s, to the case of Sidaway and the Board of Governors of the Bethlehem Royal Hospital, which is in the larger bundle of authorities at page 15.
Sorry, I'm not sure what you mean by larger.
Supplementary bundle, I'm sorry, my Lord.
Yeah, supplementary.
I think it's supplementary bundle. I'm assuming it's volume 1 because it's only page 15. I hope.
Yes, sorry, I'm being a bit slow in.
Okay, there's a lot of documentation.
That's supplementary bundle 3, here it is. No, it isn't. Forgive me, I'm, yes, here it is.
Thank you. I don't have time, my Lord, my Lady, to descend into the factual background of this case, but it was a medical negligence claim. Lord Scarman dissents, but he says something that's then picked up upon by Lord Kerr in Montgomery. So if I could ask my Lord, my Lady, to please turn to internal page 882 or pagination at the bottom 26. And I'm asking, please, my lords, my lady, to read at 882 from C down to E. And a further passage, please, on page 885 or page 29. And ask my lord, my lady, to read from 885H. It is, I suggest, forward to 886, just below B, ending at informed. And the autonomy of the individual's patient's decision-making, we say, is essentially important, particularly in respect of what is a highly personal treatment, the treatment of gender dysphoria. And that leads us to submit, my lords, my lady, that one of the errors of paragraph 138 is it ignores precisely what Lord Scarman warns of in Sidaway, that there are medical factors, but there are the wider factors that are important to the patient. And whilst that is a case regarding risks in consent, we say it has application for Gillick competency. And Lord Kerr mirrors what is said by Lord Scarman in the Montgomery decision, which is where I go next, which is in the core bundle of authorities. I'm sorry, I have the approach jumping around all these bundles. So the core bundle of authorities at Montgomery, yeah, it's page 283 that I'm asking the court to look at. Starts at 264, and I don't think the court can be taken to it. But the passage that I would ask my lords, my ladies to read is on page 283, paragraph 46, where he picks up on from what I've just asked my lords, my ladies to look at from Lord Scarman in Sidaway. Now again, Montgomery is a case about consent and consent of an adult, but we say that those principles are important because if a clinician is undertaking the factual inquiry as to whether a child is Gillick competent, they must consider the medical factors, but also the child's wider factors. And that's very important for a child, or indeed an adult's, autonomy. And if I may draw on a brief analogy, a child, let's say a 14-year-old girl, is involved in a car accident and has a badly injured knee. She's seen by a consultant orthopedic surgeon who assesses that she will have reasonable mobility back into her knee if she doesn't have surgery, but there is a surgical procedure which is relatively high risk. The child says they want to have the surgery, notwithstanding the risk. Now, the clinician may be concerned regarding whether they fully appreciate the fact that they will have mobility without the surgery. But if the child tells the clinician, I have a contract to play for Chelsea Women's Juniors, then that is an important and relevant factor, both for the child but also for the clinician, and assessing Gillick competence, because personal factors must bear upon intelligence, maturity, and understanding. And our concern with paragraph 138 is all of that is stripped away, and the focus is only on medical factors, which is inconsistent, we say, with Gillick, Sidaway, and Montgomery, where the risks and the assessment of Gillick competence must consider the patient's autonomy. And my lords, my lady, without turning it up, if one goes to the service specification, you will recall there was an appendix 6, which is one page dealing with competence. At page 541 of the, I believe it's the core bundle, you will see at the bottom of appendix 6 a reference to the personal circumstances of the patient. That seems to have been lost in the equation and is not consistent with the autonomy of child patients, or indeed adult patients. I don't have more time to spend on the law, so I'll move swiftly to section 2, which is dealing very briefly with some aspects of the evidence. I don't ask my lords, my ladies, to turn it up, but you have in the unagreed, no, sorry, you have in the second supplemental bundle at page 28 the CQC reports in respect of competence and capacity for UCLH and Leeds. They haven't technically been admitted, but I would ask that they are admitted. There's no objection to their admission. They were produced, I believe, in January of this year, and they provide a very positive assessment of the capacity and competence and consent procedures and practice at both trusts. But I don't have time to take my lords, my lady, to that. But it's important because it chimes with Miss Morris's submission that there is a regulatory regime for oversight. And inasmuch as the claimants, the respondents, have concerns, CQC inspectors who are trained in this area carry out visits and check the integrity of the consent, competence and capacity decision-making of the trusts in this area.
Sorry, could you just give me the reference again?
My lady, of course, it's the second supplementary bundle, and it begins at page 28 with UCLH, and Leeds follows on immediately behind, my lady.
Thank you.
28, my lord, yes. Can I please pick up on a few small points of the endocrine evidence, starting with Professor Butler's evidence, which is in the supplementary bundle, and I ask the court please to go to his second statement at page 247. And I just wish to make two small points in respect of statistics, which may or may not have force. As heard, my lord, the Lord Chief Justice comments regarding the helpfulness of statistics in an application for judicial review. But these statistics make two important points. Paragraph 9 on 247, there is a distinct gap for the median age, for the age at which consent is taken for puberty blockers and cross-sex hormones. For puberty blockers, it's 14.6 years, and for cross-sex hormones, it's 17.4. We say that's significant and was overlooked by the court below when they say that cross-sex hormones as a treatment must simply flow from and follow from puberty blockers. A large period of maturation will happen for many children and adolescents during that period, and they will have significant understanding of the effect of puberty blockers on their physiological and psychological development. The second point, which is important, is at paragraph 10, where Professor Butler confirms that, as against the available records of the 158 young people referred to UCLH, in respect to stage 1 and stage 2, 28 began the treatment and stopped partway through at either stage. Now, whilst we accept many patients will go from stage 1 to stage 2, from puberty blockers to cross-sex hormones, the important point about that figure is many patients discontinue the treatment, 28%. So we would not agree with the characterization of puberty blockers and onwards as an inexorable pathway the Divisional Court described it. If I could please ask my Lord, my Lady, then to look at Dr. Alvey's statement, to look at the comparable figures for Leeds. That's at page 274. And at 274 and 275, paragraphs 17 and 21, the head note figures are the median age for puberty blockers is 15.9 and cross-sex hormones is 17.2. And again, importantly, at paragraph 17, of the 183 patients referred, 145 had signed consent obtained at Leeds. 38 had delays to treatment or no treatment for the reasons set out in the box at the bottom of 274. It is something of an evidential frustration that that table didn't bottom out the issue of were any of those patients, did they not progress because they were considered not to be Gillick competent at that stage. And that was a concern, which I understand why the Divisional Court said that, but it's not necessarily excluded by the information of paragraph 17. A significant number were not considered to be determined to have consent. 145 out of 183 did, but there's a significant number who didn't. And again, does not demonstrate that referral to one of the trusts is a pathway that leads to cross-sex hormones and surgery. The figures in respect of surgery are not contained anywhere because the claimant respondent's case didn't suggest that there was a pathway from puberty blockers to cross-sex hormones to surgery. So we don't have the median age for surgery. It has to be post-18. I don't know when it is. That evidence wasn't there, but nonetheless, the Divisional Court incorporated the consequences of surgery into paragraph 138 without knowing little or anything about the basis for that. Can I then turn to the information sheet and the consent form that the endocrine trusts both use for stage 1 puberty blockers? Turning first, please, to page 324.
Four.
324, my lord, yes. It should be entitled Information about the gonadotropin releasing hormone analog to block puberty, the blocker. This is the information sheet provided to a patient at the endocrine trust. I understand from paragraph 150 of the Divisional Court's judgment, the court did not find complaint with this information. The complaint was that it would be very difficult, depending on age grouping, for a child to be Gillick competent in respect to this information. But we say it accurately and properly sets out the benefits and risks and information and clearly deals with the question of fertility separately for males and females on page 325. There doesn't seem to be any particular challenge anymore in respect of this document or the court's finding in respect of it.
Sorry, I must be in the wrong place.
I'm sorry, madam.
It's certainly not 324 in the core bundle. Which bundle is it?
It's the supplementary bundle. I'm sorry, my lord. It followed on from Dr. Alvey's statement.
Oh, right. Yes, okay.
I shall pause. 324 of the supplementary.
Yes.
And then one finds, my lords, my lady, the actual consent form at page 389.
Could I just ask a rather basic question about this document? Where does it actually end? Is it just at the bottom? at the bottom, we've got a little page number 43, which I assume has come from the proceedings below, but I'm not sure.
Bring it back.
So that we've got 2 pages which are produced by UCLH, and then so that's it's those 2 pages, is it?
It's simply those 2 pages, my lord.
Fine,
Yes.
that's all I need
Yeah.
to be clear about.
Yes.
Because then we've got one from Leeds, I think.
The document at 324 is from Tavistock, UCL, and Leeds.
Aha.
It's an agreed document across the trusts. And then 389 is the actual consent form, which must be signed by the patient, setting out the factors, and it should be signed by the parent or carer.
So it says that I agree. This is the consent form given to the trust, not the consent form at Count Tavistock.
Yes, this consent form would be used by the paediatric endocrinologist at the end of the process, considering the physiological tests, the ongoing work. Several consultations would take place with the consultant, and then if the consultant takes the view they are Gillick competent or have capacity, consent is then obtained if they are and are willing.
And have you got a reference for the one that they signed for Tavistock? I expect Ms. Morris can give us that.
Yes, I will have to leave that to Ms. Morris, my lord. There are separate forms for cross-sex hormones. And they're very different. If one goes forward, please, last document, to 397. Page 397, 398. This is the consent form in respect of female sex hormones, estrogen, benefits, risks, and the form. Now, I've given, my lords, my lady, the median ages. They're some way apart. The information and the risks are different, and these are separate processes. So in conclusion, my lords, my lady, picking up section 3 in the very little time left to me, we say, looking at all of that, when one gets to the declaration made in respect of paragraph 138, that declaration was wrong because, first of all, it doesn't grapple with the fact that as a clinician who must carry out a factual inquiry for a particular child, simply references the child, but that's not consistent with Gillick or the autonomy of an individual patient. See Sidaway and Montgomery. It's secondly wrong, my lords, my lady, because it imports some of the language of the Mental Capacity Act, inconsistent with the common law approach, well established and binding on the divisional court in respect to Gillick. It does not properly set out any relevant information regarding the individual characteristics of a child and factors that would be important to them. And for the reasons that are set out by the Tavistock in their grounds for appeal and also in our written submission, it improperly determines questions of medical evidence which were disputed. And whilst I pay tribute to Mr. Himes' forensic skill in going through the evidence the defendant filed in the court below, ultimately that evidence must be read in a consistent and holistic manner. And Professor Butler and Dr. Alvey are clear in their evidence that this is not an experimental treatment. that puberty blockers are physiologically reversible. There is no inexorable pathway from puberty blockers to cross-sex hormones. And that the question of surgery is even further afield. I've provided to the court the median ages. Don't know what it is for surgery, but these are three distinct decisions. Why would they be collapsed into one? That is not the evidence of Professor Butler or Dr. Alvey, and it has to be read in a proper way. The types of points that Mr. Himes makes may well have been points that could and should have been put in cross-examination if there was a private law claim. But of course they weren't, and they cannot diminish the overall thrust of the evidence of Professor Butler and Dr. Alvey. So for all these reasons, my lords, my lady, we say the declaration is wrong. If the declaration is wrong, then the guidance must also be wrong because it's predicated on that. And setting aside both the guidance and the declaration will restore, crucially what's important, certainty for clinicians who must be able to apply Gillick in a straightforward way for the reasons I've sought to explain. And secondly, it restores proper autonomy to the decision-making of children and young people. May I just turn my back, my lord? Unless I can assist any further.
No, thank you very much indeed, Mr. McKendry. Mr. Skinner.
My lord, my lady, firstly I should extend my client's thanks for the court's permission to continue with this intervention. By way of introduction very briefly to my client, Transgender Trend is an a-religious, apolitical, and not-for-profit organisation which provides evidence-based information and resources to parents and schools concerning children with gender dysphoria. Transgender Trend intervened in these proceedings because of what it considers to be the troubling nature of the defendant's approach to the taking of consent and the lack of full understanding of the context in which those decisions take place. I hope that the court will have seen already that the director of Transgender Trend, Mrs. Davies-Arai, has filed a witness statement in these proceedings. I don't propose to take the court through it, but that outlines some of her concerns about the broader contextual factors which form part of the background to these proceedings, and the court will find that, just for the court's reference, at supplemental bundle tab 15, page 410. Before turning to the structure of my submissions, there are just two very small bits of housekeeping. The first, just in light of my Lady Justice King not having the written submissions of Mr. McKendrick, I just wanted to check whether my lady had our skeleton argument. It ought to be at page 301 of the core bundle. But again, the core bundle was prepared before the skeletons were put in.
Your skeleton argument from the first instance?
No, for the
Oh no, for today. No, I've had your.
Okay, great.
No, what I was missing was skeleton arguments from below.
Oh, I see. I'm grateful. The second very short piece of housekeeping, I just will hand off a short extract, which I've given to my learned friends from Dismissed Judicial Review, which goes to the question, I think, first raised by my Lord Chief Justice about the nature of what one might term an existential question, sort of why are we here? And it assists on that. So if I could just hand that up, I'd be grateful.
So what are you handing up?
It's an extract from Dismissed Judicial Review, and it's from part of Chapter 18. I can provide it electronically after the course, if that would be the course. I'll be coming to it in due course rather than now, but just thought it would be easier to have it at the start rather than deal with that halfway through the submissions. In terms of the structure of where I intend to go, first I want to try and fill some of the gaps in how the case was put below. I hope that will be of assistance to the court in understanding why the Divisional Court felt it was appropriate and desirable to make the declaration and give the guidance that it did. And I hope in doing so to be able to alleviate some of the concerns about that, because my ultimate submission will be that it was appropriate and it both to exercise its discretion to make a declaration and give guidance, and as to the declaration and guidance that it gave. So that's the second point, really, is I'm going to address why we say that they weren't wrong within the relevant meaning necessary on appeal, either to make the declaration or to give the guidance. Thirdly, I want to just make some brief observations, and I will keep them brief, on ground 8, on the Human Rights Act ground. And fourthly, just in light of some of the things that Mr. McKendrick has just said about the Mental Capacity Act, I have 2 sentences to just add on that. In our skeleton, we've made some very brief observations on the other grounds of appeal. I'm not going to deal with them, but only as a matter of, only because of the time constraints that I'm under, not because I'm in any way sort of abandoning them or anything like that. And I would just invite the court to reread that when it has the opportunity, please, as to what we say about the other grounds of appeal. So, the first part of my submissions, how do we get here? It's right, first of all, that the court gave guidance in response to an invitation by me to do so. Now, importantly, that invitation, and I'll take the court to the bit of the transcript where I made it, was premised on the claimant not making out any of his grounds of judicial review. We see that. It's in the core bundle, page 261. I don't think anybody's using tabs, are they? It's tab 6, if that's 7, if that helps. But it's page 261. These are about...
Yes.
It's about halfway down the page at letter D, halfway across, the sentence starting, insofar as the court finds against the claimant, there's the premise of my invitation, then it would be useful in my submission for the court to, probably for the defendant just as much as anyone else, to give some guidance as to the way in which these contextual factors are or are not, in your ladyship's and your lordship's judgment, relevant and salient factors which ought to be considered in the consent process. And then I apologise if I've gone over my allocated time. So that's where this comes from. That's the genesis of well, the court could, of course, have done it of its own volition, but I suspect it did it on my invitation.
So just to be clear, is that the genesis of paragraph 138, or the genesis of the subsequent guidance about having to apply to the court?
So what I haven't done there is be specific about what that guidance should contain. But my submission is that both, in a sense, the factors listed in 138 and the guidance that follow from that, there was no discussion that I recall, I'll be corrected by one of my learned friends if I'm wrong, at the hearing really about whether a declaration was appropriate or not appropriate relief to grant, or in respect of which parts of the judgment it was appropriate. But at the hand down, there was, it was, I think in the judgment they'd already said we'll make the declaration in the terms of 138. But that whole, I mean, all of it is guidance. Of course, it has a different legal status depending on which bit of it, but the guidance as to which are the, what I'm going to call the minimum salient factors, because my answer to Mr. McKendrick's point about an individual-centric approach, centred approach, is of course that, of course, some children may have particular need for their knees, in his example, or whatever, but these are the salient factors which the court thought were necessary in every case. Of course, there might be other things which, I don't want to be too flippant about it, but you know, if you have a child actor, for example, who will be limited in their career as an actor as to the type of roles that they play, if they change their presentation of their gender, those are the sorts of things that you might then want them to explore in addition to those factors. I appreciate that's probably not the best example, but it's sort of what I've come up with on my feet. So my submission is that's the genesis of where we get all of this. Of course, declaratory relief is what was being sought by the claimant, but not as to the salient factors, because the claimant's case, or at least its primary case, was children are not capacitous to consent at all. And that's why this invitation is premised on that not succeeding. That it's saying, if the claimant fails in its claim, I'll come on to the DeSmith extract is useful because there's no case that suggests that there's some sort of jurisdictional bar or jurisdictional prerequisite to having found an illegality before you go on to give guidance or make declarations as to the proper legal status. I entirely accept the point that my Lord the Lord Chief Justice made, that in a judicial review, it is normal, of course it is, because judicial review is normally used to challenge what are said to be illegal acts, as they were here. But that doesn't preclude the court if it finds that on the facts, here at a level of generality, there is nothing specifically unlawful. Where there is cause for concern, and I'm going to come on to why there was in this case, if there is a cause for concern and a real reason for giving guidance, the court is entitled to exercise its discretion, and it is a discretion, with all that means for this court, to grant a declaration and give guidance. So I said I would come on to what was concerning about this case. Now, Mr. Hyam has very eloquently dealt with some of the factual matters, and I will touch on some of those, but I did want to touch on an issue of law, because it was suggested yesterday, I think it was by my Lord the Lord Chief Justice, that there wasn't really much dispute about the law in this case. And that's right in this court. That isn't right in the court below. There was a significant dispute about the effect of the Montgomery decision on what that meant for Gillick, and whether Gillick was, it wasn't quite said to be overruled, but to what extent they were consistent with one another. Because of time, I'm just going to give you references, if I may, but the claimant's submission was, actually, I'm going to just take you to one passage in Gillick before I summarise the submission, because this is really the key passage that occupied the legal debate before the court below. The wrong bundle. So it's on page 294 of the core authorities bundle, and it's paragraph 87 in the joint judgment of Lord Kerr and Lord Reed. About halfway down that page, I'm going to start from the end, if I may. I appreciate it's a little bit backwards.
Sorry, could I have the page number again?
Sorry, internal page 1463. The electronic page is 294.
Thank you. Mm-hmm.
And the sentence which caused so much consternation, if I can put it that way, was at the end of this paragraph, where it starts, the test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, etc. It's that part of that sentence that was really the passage that we were debating. And the claimant's submission on that, which is, I'm just going to give you the references to where this is recorded in the judgment. The claimant's submission on that, which is recorded at paragraph 122 in the Divisional Court's judgment, was that that meant a reasonable person in the context of an adult. So you didn't judge it by the standards of a reasonable 11-year-old, say, you judged it by what an adult would think was reasonable. That was rejected. The defendant's submission, the court describes as went to the opposite extreme. And the Tavistock submission, and I emphasise this because the court's understanding of what the Tavistock say the law is in this area is obviously of prime importance to whether the court thinks that it needs to give guidance so that the Tavistock, if it's got the law wrong, is able to correct its processes and procedures. The defendant's submission, the opposite extreme, was that the salient information that needed to be provided was that to which a reasonable child, equivalent to that whose capacity to consent is being assessed, would attach importance. Now, so far so good. The effect of that would be that given, say, a reasonable, say, 10-year-old may not have any real concept of what loss of fertility entails, what loss of sexual function entails, and therefore may not ascribe any importance to it, whereas perhaps a 15-year-old or an adult would, the court's concern, and I've come on to where this is plain from the transcript, was that what the Tavistock was suggesting is that in order for children to be capacitous to consent to puberty blocking treatment, you didn't take into account the factors which they might think in the future were really important to them, not just those factors at the time. And you can, again, I'm just going to give references just because of the limitations of time, if I may, but one can see how concerned the court was about this at various points in the transcript. And if I could just give you the references, we see the president asking twice, who is P? Who is this reasonable patient? On page 208. She asks it twice at lines E, or paragraph E and H. We see at page 210, G to H, Mrs. Justice Lieven seeks to test Miss Morris's submission on it. Mrs. Justice Lieven comes back to it at 222E, and she asks for help in determining what is salient for a 12-year-old and what is salient for that person in the future. And we then see Mr. Justice, Lord Justice Lewis, at pages 223E and 224A of the transcript, where he is concerned, he brings it back to the concrete example of the, I think it was 3, 10 and 11-year-olds who had given their consent to this, and he was obviously concerned to understand what the consent requirements were that were being imposed on these very young children. And so he brought it back to sort of more concrete aspects of the case. And just for completeness, my submission was that what you do is you take into account was that Montgomery was irrelevant, firstly, because this passage, if one reads from earlier in paragraph 87, the premise of what is said there is, we see it expressly, an adult of sound mind is entitled to decide which, if any, of the available forms of treatment, and her consent must be obtained before treatment interfering with bodily integrity is undertaken. The doctor is therefore under duty, and then we see the negligence duty set out, and the test of materiality is expressed in that context. So what Montgomery is dealing with is somebody who is capacitous. You can't use the test to be applied when somebody has capacity to determine whether they have capacity. It's circular. So my submission was that it's irrelevant, and that what Montgomery was irrelevant, and what the court ought to do is take into account factors which in the future will be objectively salient, reasonably foreseeable likelihood. The court at 132 accepted that submission, and that view of the law, that submission on that approach to the legal test is now not challenged in this appeal. So given that the Tavistock appeared to be suggesting that it did not require a young child to understand things that it would be reasonably expected might become important to them, one can see why the court below considered it appropriate to give the guidance it did, and to make the declaration it did, to make sure that its view of the law, the court's view of the law, and it is ultimately the court that is obviously the arbiter of the law, would then be applied. So that's the legal concerns. There are obviously, of course, a number of factual concerns about this treatment and about the factual matrix in which these decisions are being taken. There are, I would emphasise 6, and I can do this very briefly. The first is the vulnerability of the children that we're talking about. Gender dysphoria is, we all agree, a serious psychological condition, recognised in the relevant handbooks, DSM. It causes distress. It is associated with a disproportionate number of patients who have other mental health conditions. Autistic spectrum disorders are very prevalent among gender dysphoric patients, and as are other mental illnesses. And that's recorded in the, I don't think that's controversial, and that's recorded in the judgment of the court. The second relevant sort of cause for concern, factual cause for concern, is the ability to obtain this treatment not through the defendant and the first and second interveners. Of course, I accept what Ms. Morris said, that this is a challenge to their policies and practice, but consent is not dependent on who is providing that service, axiomatically. And in the claimant's, I think it was their, I forget whether it was skeleton, it's page 566E of the core bundle, I think it must have been their skeleton argument. The claimant gave an example of an organisation called Gender GP, who were a private GP who people were going to, and one of the witnesses, one of the transgender children who gives evidence in these proceedings, got their puberty blockers from Gender GP. They were, I think, disbarred by the General Medical Council, set up shop in Spain so that they could avoid the regulation that Ms. Morris relies on, and carry on supplying these drugs to children. That's, of course, that doesn't affect the analysis of consent, but that is the background against which these decisions are being made. And this guidance is not just applicable to the defendants and the first and second interveners, but by anybody, whether licensed, whether properly regulated or not. It sets out clearly when, well, certainly when they won't have a defence to a claim in battery. You know, if a patient is wrongly prescribed, you know, comes down the line, decides, actually, I did not give my consent to this treatment, and I want to bring a claim for the harm that I've suffered against the doctor that prescribed this to me, then it is clear that if the child did not have the ability to understand and weigh up the factors in paragraph 138 as a minimum, then that is unlikely to provide a defence to that claim. The third relevant factor is that the appellant's position below, and I understand it's still the position, is that it has never and had never contemplated ever seeking an order of the court for the prescription of puberty, or for the referral or prescription of puberty blockers in those that lack capacity to consent. And of itself, that is ambiguous as to whether it's troubling or not, but it clearly leaves open the possibility that young children who can't consent to these processes, that sufficient thought isn't going into whether or not the court's jurisdiction ought to be invoked. The fourth factor, or issue, factual issue, is one that's set out, if I could just take the court very briefly to it, it's core bundle 610. This was the defendant's skeleton argument below, and paragraph 95 is the relevant paragraph. The test was so the beginning of 95. This is quoted from Montgomery, and there's nothing wrong with this summary of Montgomery, but the concern is that what's being said here is that a doctor has a duty to use reasonable care to ensure that a patient is aware of material risks. Now, that's unobjectionable, of course, as a matter of the law of negligence. And one gets into Bolam and what happens if you depart from standard procedure, on which Miss Morris, to which Miss Morris averted. But of course, this isn't a negligence issue. This is a consent issue and a trespass to the person issue. And that indicates, in my submission, a wider concern for whether or not the defendant is properly considering these issues in the round. And Mr. McKendrick's submissions to some extent echoed this, put it slightly differently, but it echoed this concern, if I can put it like that, which was that these are matters for the clinician. And that's very redolent, if I can say so with respect, of suggesting that this is a hands-off scenario where you leave it to the expertise of the treating doctor. And of course I accept that in an individual case, whether or not a child is able to consent will necessarily involve the assessment by a treating clinician, of course. But ultimately, this isn't a negligence case. This is a binary, are you consenting or aren't you consenting issue. The final three factors I can take very briefly, because Mr. Hines already touched on them, and I'm very conscious of time, was the lack of data in relation to either the number of gender dysphoria sufferers referred for puberty blockers who had autism or other mental illnesses. We just don't know what the figures are. There's none before the court. The lack of data showing the numbers who are on puberty blockers who move to cross-sex hormones. Again, why the defendant appeared not to have been gathering that information. That's something the court, in characteristically judicial language, described as surprising. The fact that the defendant themselves had commenced a research study 9 years ago about the effects of puberty blockers, which at the hearing was said, or in Dr. Carmichael's evidence was said was being finalised, and then Ms. Morris quite properly brought the court up to date, and it was said, well, that's on the desk, effectively, of somebody that's responding to peer review comments, but no, I would say, no compliance with duty of candour to at least bring to the court's attention what the broad results were. And of course, the CQC report that came out subsequently wasn't before the court, but because it was ex post of the event. But of course, some of those concerns are borne out in it. And so what you had below in my submission is a real dispute about whether the law is being properly applied in the context of very concerning factual matters, which amply justify, in my submission, the court acceding to my invitation to give guidance, even in the absence of a finding or a holding that anything illegal was unlawful, perhaps a better word, was happening or had been made out on the grounds.
Yes, well, obviously one can make and listen to criticisms of the evidence below, but one shouldn't overlook the fact that the purpose of a respondent or defendant's evidence in judicial review proceedings is to respond to the claim that has been made. And I come back to something I observed yesterday. This seems to be expanding into almost expecting a general inquiry into all sorts of things. But a lot of the material that you're referring to, at least as it seems to me at the moment, simply did not arise on the claim that was advanced against the defendant, and it was never pleaded in the way that it was advanced. And these are not trivial matters.
Can I respond to that in two stages? The first is just to, I entirely accept, and I think all parties before the court accept that this is not a general inquiry into the appropriateness or otherwise of puberty blockers as a treatment. That's not the case that I made below, that we made below, that the claimants made below, and that's not the claim, and that's not what your lordships and your ladyship are being asked to determine on this appeal. What was squarely before the court below was the extent to which children can or can't, and it follows from that, and in what circumstances, if they can, consent to puberty blocking treatment. And so it was squarely before the court the question of the circumstances in which a child can consent. Now, how high you put the submission obviously varies between us. Mr. Hyam's submission was that never is the answer, and I didn't go that far. But that's the first sort of part of my response, if I may. And the second is I entirely accept that the defendant's evidence is to meet the claim, but it's and this touches on, I think, a point that Your Lordship made yesterday about the at least starting point is that you accept the defendant's evidence absent cross-examination of the defendant's witnesses. That's true in relation to what can properly be called factual evidence. I accept that that is correct, and it's readily understandable why that's the position, because the normal evidence that a defendant gives in judicial review proceedings is of the matters it took into account in coming to the particular decision, what was in the decision maker's mind, what equality considerations were taken into account before the decision was reached. So it's normally evidence of the defendant's own processes, which it's very difficult to see, absent some sort of allegation that the relevant civil servant or minister is giving evidence in bad faith, is lying or whatever. It's very difficult to see how in at least most cases, you could possibly go behind that. And so as a starting point, and it is in the authorities recognise there are instances where you go behind, where you don't adopt that approach, it's a sensible rule of thumb. It's not it doesn't answer the question in relation to expert evidence, because of course, I mean, Mr. McKendrick made the point that Dr. Butler says this is not experimental treatment. But of course, the description, to say something is or is not experimental, begs the question of, well, what do you mean by experimental? But to say something is not experimental or is experimental is an expression of opinion about something. Now, of course, as the divisional court did, you might then define it better and say, on my definition of experimental, it meets that definition, and I'm going to use that as a helpful shorthand for the evidence base is low, there are lots of unknowns, and all of those issues of fact, which in reality there is a very, if any, there's not really any dispute between the parties on those primary factual matters. And so just because a defendant says this is not experimental treatment, that is not something which any authority that I'm aware of suggests the court has to simply accept because it comes from the mouth of the defendant. It's not the sort of matter where the issues about the decision-making process apply, and that's the rationale for this rule. And so I would say, well, I mean, I agree with Mr. Hyam that this issue of expert evidence doesn't arise because the court can be taken to have done what it said it was doing. You know, you have the President of the Queen's Bench Division, a Lord Justice of Appeal, and an experienced High Court judge, great experience of public law on the bench, and if I may say so, Lord Justice Lewis's approach to evidential rigour is second to none when he was sitting in the admin court. He is a judge that is well alive to the difficulties of expert evidence in judicial review, the need to put a document in with a witness statement, all of the sort of things that might get overlooked from time to time. That's not the sort of approach that he takes. Now, I appreciate that's not an answer to the point that's made, and I appreciate also that it's not an answer to say, it's not a complete answer to say that the court said that it wasn't resolving disputes of fact, and it wasn't resolving issues of expert evidence. I appreciate that that's not a complete answer, because it might have thought that it wasn't, but it might have really done that. But I do suggest that a court of that experience and expertise is entitled to the greatest respect. And the starting point, again to use that phrase, is that if it says it's doing something, then it ought to be taken on face value that is what it's doing. So that I hope just answers my Lord Chief Justice's questions there. I'm very conscious of time, but can I just deal with very briefly the Human Rights Act and mental capacity? I'll take this very briefly. On the substance of the Human Rights Act issues, I agree with what Mr. Hyam said. I go slightly further. My submission is, in relation to Article 8, being required to go to court for a best interests decision, it cannot be an interference with your Article 8 rights. It just doesn't get over the first threshold. But even if I'm wrong on that, plainly it's justified at the final proportionality stage. in relation to discrimination, and I would just flag that Mr. Heim addressed very briefly on Articles 2 and 3, those are not in Ground 8 of the grounds that are relied upon, and so it's not permissible, just for that reason alone, for other interveners to seek to make other human rights points. Human rights law demands no less specificity than any other area of law, and just...
Well, you can, as you may have gathered, procedural rigour, it's not there for its own sake,
No,
but on a number of occasions each of us has intervened to question quite how we are where we are. I don't think you need to develop a submission that a point that isn't advanced by the appellants isn't one you can just latch on because it's mentioned by somebody who's put in written submissions.
I'm grateful. In which case, can I just make one submission on the procedure, and this is a procedural point, and the reason I raised it is actually quite an important point of principle. Now, it may not be, in light of what your Lordship's just said, necessary for you to decide it, but I do just want to flag that there is actually a quite important point of principle here, which is that there is nobody before the court, no party, interested party or intervener before the court with victim status within the meaning of Article 34. The defendant accepts that the Tavistock don't have victim status, but NGOs, unless they are affected, do not have victim status of themselves. Obviously, if in a repressive regime where NGOs are targeted and their free press right or free expression rights are interfered with, then they will have their own victim status.
Well, again, I at least speaking for myself, I readily accept that I think it's Liberty advance these arguments, don't they? And they are on any view not victims for the purposes of Article 34.
No, nor are Lawyers for Children or any of those organisations. I do say that there is a procedural bar to Ground 8. I just want to make, as I said, I would deal with 2 sentences and I'm over my time, on the Mental Capacity Act. I listened with great interest to Mr. McKendrick's submissions on it because, as we said in our skeleton, there is a lively debate to be had about the extent to which there is read over between the two or isn't. It's completely irrelevant in my submission in this case. This is not the case to decide that issue, as interesting as it is. And the reason I make that submission is because it doesn't arise. It's not a proper reading of the judgment below. Does not incorporate. There is no incorporation of the principles of the Mental Capacity Act into Gillick. We expand on these submissions at paragraphs 22 and 23 of our skeleton, and the relevant references to the judgment are there. I don't plan to detain the court any longer with that. Those, I think, are my submissions, and I come back to the basic point that this is a case involving vulnerable children who are entitled to the protection of the law, and that is what the divisional court tried to do. And in my submission, they did so appropriately and can't be said to be wrong in their approach or in the outcome.
Now, just before you finish, if you just want to tell us which paragraphs in the latest edition of the Smith.
Apologies.
This is the. Oh, well, I see. It's the page and a half, 2-page discussion on declaration.
The particular parts that I would just draw the court's attention to, paragraph 18038. I would suggest that the court reads the whole paragraph, but the particularly important sentence is the one about 7 or 8 lines down, beginning, however, as will be seen.
Oh, yes.
And then, if one goes over to 18042 and 43, we get the issue of theoretical or hypothetical judicial reviews is dealt with. And at the top of page 1005, we say the hypothetical question is a question which needs to be answered for a real practical purpose, although there may not be an immediate situation on which the decision will have practical effect. So, I mean, that's what we say this is. And then I would just also draw the court's attention to 1843. The court has jurisdiction to make advisory declarations. That's obviously not disputed. 2 main functions. First, to reduce the danger of administrative activities being declared illegal retrospectively. Well, that goes to my trespass point and making sure that the guidance is out there for the rest of the world, and to guide, possibly 2 sides of the same coin, to guide public authorities by giving advice on legal questions, which is then binding on everyone. So those are the particular.
Well, and the authorities referred to in the footnotes are not entirely unfamiliar,
No, of course.
and particularly those that cautioned against it, as you will.
I would actually, can I just draw to the court's attention, paragraph 114 does make, footnote 114 does make that specific point, that the courts do caution against it. For the reasons I've already given, this is a case in which, I mean, I would say it is appropriate,
Yes,
but
well,
it's plain entitled, the court was entitled to find it
We
appropriate.
understand your submission.
We're grateful.
Thank you very much indeed, Mr. Skinner. Well, Miss Morris.
May I address one submission made by my friend Mr. Skinner, and he appeared to renew an attack on the way in which consent is taken, on the basis that it is taken in a fashion which is child specific. Lord, the point about Gillick is that the testing of competence is child and condition and treatment specific. And what the court will have seen from looking at the documents is that that discussion leading up to the establishment of competence or consent involves projections into the future in the way that the court has seen and what might be the case, might not be the case. It's also perhaps worth bearing in mind that a paper that the learned friend took you to, my own Mr. Heim took you to this morning, which is just your note, supplementary bundle, page 651, an academic paper concerning the ability of children to understand, although he didn't take you to this paragraph, specifically acknowledges that a child with a particular condition will have particular insights as a result of their experiences, and therefore one can't generalise. And of course, in that sense, academic understanding is completely in step with the understanding of the law, which is it is always something to be understood in a particular case. Now, may I just turn to my Lord's query about the consent form from the Tavistock? My Lord, that appears with the SOP, but that part of the SOP didn't make it into the bundle because of the strictures that there are on the numbers of pages, and we had to accommodate what everybody wanted. So we also would say in our defence, in seeking to accommodate everyone, that we noted that nothing was said about the SOP in any of the skeletons, and therefore we hadn't understood it to be as important as it appeared to have been in the course of submissions today. So of course we can provide that material to the court. We're very happy to do so. It's Appendix D, and I think we get as far as Appendix C before trying to accommodate others.
Was it not before the court below?
Yes, but my Lord, you'll recall that we had to make an application for a longer bundle than, and
it was before the court.
it was before the court below. And of course, the other point, perhaps, Lord, is there was even more voluminous material which reflected that which took place before the institution of the SOP. So, in fact, just to pick up a point from my lady as well about my use of the word historic, so I'm not going to argue about that, but just to put the chronology in place, what the CQC notes, and again for your note, it's in the unagreed bundle at page 229, is that its concerns about recording in relation to consent applied up to January 2020, which was the advent of the SOP. So the SOP was a corrective process. But I'm assuming that it will be sufficient for this court's purpose if we give the court Appendix D of the SOP and not all the huge bundle of historic material. The next point then is just to return to this question of how the court dealt with the expert evidence advanced by the respondents. Now, we explained to the court yesterday and showed the court the Law Society Authority. But it's perhaps worth emphasising, because it was queried, I think, by Mr. Heim, whether we really effectively made enough fuss about it, was that we did address in our skeleton below the issue of whether this material should be admitted. And we didn't just rely on the Law Society case. We also took the court to a decision made by Dame Victoria Sharp and Mr. Justice Lewis, as he then was, just a few months earlier, in the Chief Constable of Hampshire case, where they addressed a virtually identical situation, namely a situation where a claimant sought to rely on expert evidence for which they had not sought permission. My Lords, we set out the core parts of that judgment in our skeleton, but also you may wish to note the authority in its entirety, and it's in the supplemental bundle of authorities at tab 31. And the key part of it is at page 759 of that supplementary bundle of authorities, at paragraph 116. So, lady, I see you're tying it up. I don't want to delay people too much. Just to make the point that the position taken by the defendant was drawing the court, that's to the principal authorities, but also to a recent and specific instance where the very same individuals had applied it. We considered that we had done enough to draw the matter to the attention of the court. And the question then is, if the court did make a mistake in its approach to the admission of evidence, what does that mean for not only the order but the judgment? Because one of the questions that's been ventilated after the last 2 days is, well, what do we do about the guidance in the judgment? And we say, if this court is satisfied that there was a serious procedural error, it should have a serious pause about allowing guidance to stand, which arises out of determinations reached following such a procedural error. Further, we say that that serious procedural error did have a real effect, and I wonder if I can perhaps give you 2 examples of that. One is, for example, the issue that was taken by the claimant and repeated by Mr. Hyam in his submissions this morning, and that's the issue of whether or not there was a clear purpose to the treatment. So you'll recall that one of the things which the court below says in its judgment is there's a lack of clarity about purpose. And then Mr. Hyam today showed you his skeleton argument very briefly at core bundle 553. And again, I'm not asking you to take it up, but if you return to it, you will see that the totality of that submission rests on the evidence of Professor Lieven. And so again, the source, origin of submission, and we say then a finding which was made by the court, is that evidence. Similarly, if one takes the example of the issue of whether puberty blockers are causative of a choice to take on treatment with cross-sex hormones, Mr. Hyam showed you paragraph 136 of the judgment, but again, I won't ask you to look at it now, but just for you to note, what happens between paragraph 136 when the expression vast majority is noted, so the sort of the statistical phenomenon is noted, then morphs in paragraph 137 to a causative description, we say, where it said it's a stepping stone. And then at the beginning of paragraph 138, the one which has secured so much focus, that paragraph starts, it follows that. So in our submission, what happens is at 136, there's a proper acknowledgement of a statistical phenomenon. That then becomes in paragraph 137, we say improperly a causal connection. And then in reliance upon that, the court draws up a list at paragraph 138. And we say where that reasoning contaminates a declaration, in the same way, it must surely pose a real risk, if not in fact, contaminate all the guidance which has gone along with it. Because, of course, what the court has done in 138 is identify a list of factors. All the guidance essentially refers back to that list of factors because it's directing doctors to work through them in reaching their conclusions. Turning then to the consistency or otherwise of those, of the drawing of the list of factors with the preceding case law, we would take issue with the submission of Mr. Hyam that paragraph 90 of Axon is, as he says, identical to this case. First of all, I'd adopt the submissions made by my learned friend, Mr. McKendrick, but we would say there are further powerful points of distinction. First of all, Axon is not a declaration. But secondly, and this picks up a point I understood was essayed by the court at the end of yesterday, the factors which were articulated in Gillick and in Axon were articulated in the context of very limited guidance. So guidance really which indicated that X was possible. And so when I say guidance, the statutory guidance concerned. Whereas here, this court is confronted with service specification, the standard operating procedure, and the court below has not found any illegality with that material. And so we say where a court does not identify illegality, it is hard to understand upon what basis it might assert that there is something else to be done. Now, as I understand it, what's said by my learned friends, Mr. Hyam and Mr. Skinner, is there is some free-floating discretion in the court to give guidance. Well, whether or not that's the case, we do say there is an important further procedural step that arises. So where it's not been pleaded or submitted to the court that there should be a declaration or guidance which enunciates a list of factors in that way, the very least that is required is that the court tells the parties that it is what it is considering doing. And it gives the parties, and indeed perhaps the professional bodies concerned, the opportunity to make submissions. And we say that what the court has in the process adopted and decision made by Mr. Justice Green in the Letts case is just that. So again, without taking you to it, we deal with it in our skeleton, which is at core bundle page 41, footnote 44. I blush to utter that phrase. But I wonder if I can also help you with it, because the judgment itself and the core part of it appears in the supplementary bundle of authorities at page 434, paragraph 19. So we say if the court below were minded to throw a protective cloak in the way that my learned friends have suggested it was right to, it still had to observe some elementary process requirements, and it was a serious error that it failed to do so, and that leads to a further ground why it should advance. And of course, the submissions made by my learned friend Mr. McKendrick make good the real difficulties, practical difficulties for doctors that arise if the court takes on to itself this task of identifying what is material. May I just make one other point at this stage, which is the function of the guidance given by the court, particularly right at the end of the judgment, paragraph 152. That is clearly concerned with the position of 16 and 17-year-olds who are protected by what Parliament laid down in the Family Law Reform Act. And it is our submission that the court should not weaken such a statutory protection by abstract guidance. It's certainly not disputed by my client, and we showed you the authorities, but there are, of course, cases where the court might intervene in position of life-saving or severe injury, as we showed you yesterday. But what the divisional court, administrative court, is not empowered to do is weaken a statutory protection on a sort of abstract, anticipatory basis in that fashion, and certainly not returning to my preceding submission without giving all of those affected by the giving of such guidance the opportunity to make submissions about it, because even if it were appropriate to give such guidance, surely it can only be done well in the light of submissions from endocrinologists, from paediatricians, from the BMA or the GMC, perhaps in the way that has been done in other cases, but certainly not without the benefit of that information. May I just turn my back to see if there's anything else that I've missed? I have nothing else.
Thank you.
No. Well, Ms. Morris, thank you very much indeed. We will, of course, take time to consider our decision. In the ordinary way, we will circulate judgments to the parties for typographical corrections and the correction of obvious glitches. We emphasise that in doing so, it's not an opportunity to try to re-argue the case. Obviously not in a position to say how long it will take us to produce our judgments. You've given us a lot to think about. You've given us a lot of material which we're going to have to review with some care. So it will be a little while. When we hand the judgments down, we hope that the parties will have been able to agree an appropriate order reflecting our decision, and there will be no need for any attendance at the hand down of the judgments. If there are any outstanding matters that have not been agreed between the parties, we will invite short written submissions on those matters, and we will resolve them in writing. We're very grateful to everybody for the obvious hard work that's gone into presenting these materials, and we thank you all.
All right.